Hello, I'm here with Melissa Spindler, who is a registered patent attorney whose practice includes all aspects of intellectual property law with an emphasis on brand protection and intellectual property litigation or dispute resolution. She's been in practice since 2004, and in that time, she's become adept at developing cost-effective business solutions, which we love, to legal disputes. Melissa collaborates with her clients to enforce their patent and trademark rights and defend against charges of infringement. She also works with clients to create value by creating cost-effective strategies that build intellectual property portfolios. She is passionate about bringing intellectual property knowledge to small businesses and empowering clients to gain competitive advantage by protecting their brands. Speaking to the choir, Melissa. In her free time, you'll most likely find her at a hockey rink cheering on and or chasing her kids, volunteering with the Wisconsin State Bar, or playing DJ on a family road trip and a boat outing. That sounds like so much fun. Thanks so much for being here today.
Yeah, thanks for having me.
Cool. And just anyone who's watching, I'm sharing this as part of Hustle with Aloha, which is my side project where I gather expert advice and tips and tricks for small businesses to help set y'all up for success. And hey, I'm a small business too, so I get to learn in the process. So today we're going to talk about intellectual property law, business naming, logos, branding, that kind of thing.
Awesome. And I'm excited because I also am a small business. So I love to be able to give tips and tricks to fellow business owners and also to learn from you a little bit more about branding and naming.
Awesome. Just to go back to basics, if you don't mind, because I think a lot of people are a little bit squishy on this topic, myself included, actually. When you talk about trademark law, copyright, and patent, like what is the difference? And does it really matter, I guess?
Yeah. So basically, when you think trademarks, think branding. So it can be anything. It can be a name, a logo. It can be a color. It can be a sound even. So like the NBC, dun, 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 that's trademarked. They own that.
Okay. Like
Anything.
Netflix, huh? When it's like
Yeah.
when it comes
So
on.
anything that distinguishes you from your competitors is trademark. And then copyright protects artistic expressions that are somehow fixed in a tangible medium. So when you write a book, when you make a painting or a sculpture, or when you choreograph a dance, that's all copyright. That's artistic expression that we're protecting. And then patents are going to protect inventions. So if you've developed a new widget or a new method of doing something, that would be protected by patents. But I think what we want to focus on today is like the trademarks, the branding, the what sets you apart from your competitors.
Yes, definitely. And now that you mention it, I actually have as part of my like basic service agreement that all my clients sign. I'm pretty sure it assigns all the rights and ownership to them, but I understand with artists sometimes that's not the case. Do you ever work with that?
Yeah, absolutely. So that is something that's really important to think about on the front end. So whenever you hire a creative to, let's say, design a logo for you or to develop your website, typically they're creating it for you and they're intending you to have all the rights in it. But just as a matter of law, that's not what happens unless we have an agreement in place. So what we typically work with clients on is developing an assignment agreement to say, um, the client has the rights in this. And it doesn't typically matter as far as a name because you develop trademark rights by using your name or your logo or your brand.
Mm.
But what it really is that underlying copyright in, again, a logo, anything like that.
Okay, so you just said a copyright, but would that
Yeah.
be a trademark or a copyright? Because I know a logo is an artistic expression, but it's
Yeah.
also like a
So
logo. So would it be both?
logos both.
Oh,
Um,
interesting.
So a lot of times people aren't really as focused on protecting the underlying copyright in a logo, but because they're mostly looking at the protection from a brand standpoint. But just to make sure all your I's are dotted and your T's are crossed, if someone else is developing that for you, you really want to make sure that there's an assignment in writing so that you can, definitively say that you own it.
Okay, so um, what you're saying is maybe it's good to like register a logo or brand name or whatever with the government for a trademark. And then if you want to register a copyright, which sounds like why not, then you need to make sure that the artist who created it has in their contract that they're assigning the rights to you. Am I understanding that correctly?
Yeah, yeah. You'll want to have that in the contract. Or have a separate, even just like one-page contract that says, I assign the rights in this
Mm.
product to you.
Okay, I could see that because sometimes graphic designers, sometimes they're illustrators, and maybe they make a logo for this one client, but maybe they're actually making illustrations that they do want to keep the rights to, but the logo, they're like, whatever, you can have it. What am I ever going to do with the logo?
Yeah, absolutely.
So that's interesting. You could just have it be like for one piece of art or one creation.
Absolutely.
Cool. Um, I can't help but ask, like, it's really common practice for website designers to just put in the footer of a website, copyright symbol, whatever the current date is, and then the client's name. I was told by my like design mentors that you do this because if anybody, like a competitor or anything, starts to copy the website or go after the client, that they do have like a grace period of enough time to like register for the copyright really quickly and then go after, but it doesn't really make sense to do it in advance. Is that ridiculous advice, or have you
Um,
heard that?
yeah, so in order to file a copyright infringement lawsuit, you need to have a registration. But you're correct that if you have that copyright notice, like you own copyright in something you create as soon as you put it out there in the world. So you own that. Now, if you want to go enforce those rights, that's when you need to have that copyright registration. And you're correct. You can go later and file for that copyright registration. There are some benefits to filing early. So if you think it's, I mean, I always say if it's like your product, so like let's not even just talk about your website because maybe that's not it. But if you're talking about a pamphlet that you've created or a workbook that you've created. Let's say you have a course and if you created a workbook, that might be something that you want to proactively register because you can get enhanced damages if you've registered your copyright either within a certain number of months after it's been published or before infringement begins. So on a website,
Fascinating.
maybe you don't worry about it because your website's always being updated, always changing a little bit. But on some of those more concrete materials, you might be interested in registering ahead of time.
Interesting. I mean, you're speaking my language, especially because I'm launching that Create Brand Gold DIY branding course in September, and it absolutely has a workbook associated with it. What would I mean, for my benefit and anybody watching, like, what does that look like? What if I wanted to have your help to register that as a copyright? Do I need to submit it to the government? Is it something I can do? Should I hire you to do it? Do you just come in when somebody like infringes, or what does that look like?
Any of that. We definitely help clients with registering copyrights. We tend to do that especially when we have clients who like that's their main business is like preparing training materials. Um,
Mm.
Copyright, there is the ability for you to file your own copyright application. All of that information is available on the Copyright Office website, which I don't have it offhand, but
That's okay. We can put it in the show notes later.
we have a ton of resources though. A lot of times, even when I'm trying to, copyright's a really particular area of law, so everything's really fact specific. So a lot of times I start looking at the Office website and looking at all the circulars and information they publish. It's a great resource.
Huh. That's great to know. Okay. And I mean, you make it sound easy, and you're a lawyer, so you like understand how the government speaks. I feel like it potentially might be one of those things where like a tax attorney is like, oh, just file your taxes, it's easy, and then the rest of us are in tears. Is it
Yeah.
really easy, or do people find it intimidating?
I think that
It's a trick question, I guess.
No, I think you're right. I think it's not super difficult. I think the government, you're absolutely right, uses language that is not the words that we use in our daily life. So there are pitfalls. We generally charge around $500 to prepare and file a copyright application. There's usually not much back and forth on those. Usually we file it with the government, it's recorded. Unless there's some major issue, we get a registration certificate back in the course of a couple months.
Oh, takes that
And that,
long. I mean, I
and
guess they probably have a list of ones they're doing.
yeah. And so, I mean, that can be helpful, particularly if you're talking about trying to protect a logo that you didn't create, because we can make sure that we're asking the right questions to make sure we're identifying the correct author and we've got all the proper
Mm,
documents in place.
interesting. Okay. I mean, $500 doesn't seem unreasonable, especially for like legal services. So that's really good to know. Was that would that be for a name, a tagline, a logo, a workbook, a website, or is it more if it's like a more complicated document versus
Um,
like a logo versus a workbook?
so again, that's for the Copyright Office side of things.
Oh, that's their job. I see.
Protecting a trademark is like a little bit of a different animal.
Mm.
And so but that would be for any kind of material that you were looking to copyright.
That's right. Okay, because copyright is artwork, artistic expression, right?
Yes.
Sorry. So
Um,
if you were to register a logo for a business with a trademark office, what would that look like?
so we do trademark work. We typically tell clients to budget about $2,500 for a trademark to go through the process. It can be much less than that. But we'd like to set people up for just having reasonable expectations. Again, we're a small business ourselves. It really sucks to say like, oh, I can do this for $1,000 and then have it be $2,500 at the end of the day. I'd rather plan for a little bit more in advance. And then if it comes in under that budget, I'm happy.
Interesting. So it sounds like it's not as straightforward a process as like
It's
copyright.
not. So when we file a trademark application, when we file a copyright application, the government, I don't even know exactly what they do, but they do their own little, like review of it. And I don't want to say it's a rubber stamp, but they typically kind of go through. The trademark office is a more rigorous examination of the trademark. And what they do is
Mm,
two things. When you file your trademark application, of course, they look at it to see, have you filed the documentation properly? Um, but the two main things they look at are number one, is that trademark descriptive of the goods or services that you're providing? And the second thing they look at is there anyone else who has a trademark application or registration that's too similar? So is there a likelihood of confusion between the
mm.
mark that you're applying for and something that has already received protection? So, that's the analysis that they're doing. And it's a human process. So there's laws, but it's also a human process. We have a trademark examining attorney reviewing all these trademark applications and, trying to figure out what they're going to do it's hard to guess.
Interesting. So like you're on your end as the intellectual property lawyer, you're trying to guess and like submit a description that's as detailed as possible without being pedantic. And then you're probably also looking to see if there's anything else similar before you even submit it, right? And then they're just like double checking it. Is that the
Right. So it depends on what my clients want to do. We can do a trademark knockout search and we charge about $400 to do a trademark knockout search. So what that is, it's a review of the trademark office records to see if there's anything identical or really similar to your trademark or logo that's already been filed. Um, so a lot of times if I have a client who's been using their trademark for a really long time, they don't want to use that because they're like, nope, this is my name. I'm going to file. I'm just going to roll the dice. But a lot of times
Mm,
when people are sort of coming up with those names that they use that knockout search because that
okay.
is,
And so would sorry, go ahead.
oh, go ahead.
Would that be for like a name and then also the graphic representation in the logo? Would those be two separate things?
Depends on how different they are. Sometimes when different people call different things a logo. So sometimes people,
Girl, I know.
I've had people, we have a little logo that's a circle and an SK, that's on our website, on our business cards. And I've had someone tell me that's not a logo. And for the purposes of the trademark office, that is a logo. Um,
Mm,
but so there's a couple different things you can protect in the trademark office. You can protect a standard character mark, which is just the words, no reference to font or color or anything.
mm.
You can also do a stylized mark, which would be think of Disney and their Disney font.
Oh yeah.
So you can do a word that's in a particular font. You can protect that. And then there's another step where you could do like what I'm thinking of as a logo, which is truly a design element that isn't just the word
Right.
in a fancy font. Um, and so when we're talking
Okay.
about a stylized version of a word, usually that's kind of included in that search. If you have a totally separate design element, usually we're having to look at that separately.
Gotcha. So something that might technically be a word, but it's really artistically represented is like not even perhaps even a font
Right.
or maybe even an icon that doesn't have any text in it at all, but is so recognizable for a brand. Am I getting that right?
Yeah. And really, those are some of the best, like easiest to protect trademarks are the ones that are design elements because there's so many different
Right.
combinations.
Expressions of
There's
it.
only so many
Yeah.
different combinations of letters. I mean, one thing I see a lot, and I see a lot of people who should be using your services. I see a lot of people who are coming up with really descriptive names for their businesses or their product lines. Um, and so, one of the things that we talk about in the trademark world is that not all trademarks have the same value. Some trademarks are
Hmm.
much valuable than others, and there's kind of this spectrum of distinctiveness that they talk about in the trademark world. So you start with trademarks that might be generic, like trademarks that aren't really trademarks at all. They're just like the word for the product. Um, so like leather furniture for my furniture store that sells leather furniture. Like that's just generic. It's
Right.
the name, it's the name of what.
Totally.
So we start with generic and then we get to descriptive. So descriptive is something that like might describe the services that you're providing or it might describe your business somehow, but it's not like literally the exact words that are your business. Um,
Okay. Like Yahoo, maybe?
well, I think Yahoo would be
It's
more
like
of
a
an
feeling.
yeah, so like the next step up is like suggestive, right? So Netflix is
Mm,
suggestive because suggestive is like, oh, it kind of gives me an idea of what they do. Like they provide flicks, movies over the internet, but it doesn't exactly just say it or describe it. Next is arbitrary, which is a real word that just is being used for something not related to what it is. So that would be like Apple for computers. That's
yes.
arbitrary. Like that's an arbitrary word. And so I think Yahoo might be that. I mean, the word Yahoo exists.
Yeah.
Yahoo is
Right.
arbitrary for use on, a search engine.
Okay. And
Um,
is the furthest one like completely made up and it's not a word?
yes, we call that fanciful. So that's
Fanciful. I love it.
fanciful. So that would be like Adidas for shoes or Pepsi for beverages. Like those are words like that someone just made up a word. And those are the
Yeah.
most valuable, most protectable trademarks. So, and I think that that's something that is really a give and take between the lawyer and the creative, because I'm sure from your perspective, a fanciful mark until it gets that brand recognition is probably a tough sell.
It depends. Yeah. I do naming. And so it's funny. I actually, in the brainstorm process of it, we kind of go through this process where it's like we start with the generic of like, what do you do? Like, what do people experience? And then let's get a little bit more and more esoteric. Um, and I have one that I call a Franken word where we take two words and put them together, like Netflix or something like that. Um, but yeah, it's, I feel like when you're a new business, it's challenge enough to like build those connections of like individual to individual and then to people to understand what it is that you sell. And then if the name of your business is also completely like arbitrary, it's like three things and the brain can only hold so much at once. So if it at least has one tentacle, one root grounded in reality, you know, I think you have an easier time of being remembered. Or sometimes it can be a word that's unrelated to, I guess that would be, what did you say?
That
Arbitrary. It
is
would be arbitrary.
arbitrary. Yeah.
It's like at least it's a real word. Someone knows how to spell it. Spelling is also a challenge, you know, like Pepsi, we're all so familiar with it. But like when they first started, what if people were putting PEPSY, you know?
Yeah.
So,
And I will say, okay, that's one more thing that I do want to mention to you is that a lot of times people think, well, I'm just going to change the way I spell it. I'll spell it differently. And then it's not going to be trademark infringement and it's not going to be too similar. That is wrong.
ooh,
The trademark office looks at phonetic equivalence. So like, and they look at like, how does it look? How does it sound? And they also look at foreign equivalents. So if your word is just like a French word for the product, like
or
you might have,
apple, like maybe it's like palm, which is apple in French. Because you
yes,
probably
yeah,
couldn't come up with a computer company and
right.
you're like, oh, palm, it's completely different.
Totally different thing. Yeah, that Apple might have
Interesting.
something to say about that.
Yeah. Wow. So that's really interesting. Are there any other like naming pitfalls that maybe, you know, myself and people who are starting a business and naming it should look out for that you can think of?
Like I said, the main thing is making sure that you're not being descriptive. And I will say that includes descriptiveness of your product. It also includes descriptiveness of your geographic region.
Oh yeah, I always warn people about that. Because what if you expand or move? I mean, talk
Well,
about clipping your
right.
wings.
Yeah. And like let's say you had let's say you wanted to register New York bagels. I think, they'd be like,
Mm.
well, no, I mean, you're located in New York and, people know what New York is and you're selling bagels. So like, sorry guys. So a lot of the trademark office is just going to say, no, that's just descriptive. Like people are aware of
Wow.
this state, like, you know, and so that becomes a problem too. So the
I could see that
descriptiveness,
becoming a problem. Like if you wanted to start a franchise or
yeah. Well, and
even just protect yourself. Sorry, go ahead.
no, I also think people just don't think about the future when they get started. So, I mean, yeah, people sometimes have huge dreams, but they're not setting themselves up for the future when they start their businesses. So you're right. Like if you have your name be too specific as to your goods, like if you start out talking
Mm.
about computers and you're like, well, no, now I'm going to do like
Internet too or something.
and
Yeah.
I'm gonna do home audio and I'm gonna do all these different things. All of
Yeah.
a sudden you're you're not really accurately describing yourself. And maybe that's not a problem from my perspective of if your trademark's protectable or not, but it's a problem from, your business identifying
Yeah, that's
they are in the
interesting.
market.
Like be specific, but not so much that you clip your wings.
Correct. Yeah. Yeah, I mean, that's a big one. And also people don't always want to, invest in doing a search or protecting their name up front. And that's
Mm,
fine. But then when you want to expand, like I've had clients who've been in business for 15, 20 years. Well, actually, I've got a client right now who's been in business for 50 or 60 years and using a name that the trademark office believes to be descriptive of their goods and services. I disagree. I think
mm,
it's acquired meaning over the years. Now that name is associated with my client. But they're
mm.
having problems getting some trademark registrations, being able to legally protect that mark. And it
Yeah.
comes into play when people want to sell on Amazon because in order to get Amazon to take down infringing listings, Amazon wants you to be registered with their Amazon brand registry. And in order to do that, you need to have trademark rights. They've loosened it a little bit where in some cases you can have a trademark application pending, but you have to be securing those rights. And if you're in a situation where you just can't, it becomes a problem.
Wow. What a potential nightmare. Yeah. Um, that's really interesting. One of my clients, I won't say who, but like they started their company doing one particular thing. And then now they do two other things that are related, but they don't want to get rid of the name because everyone knows them. They've been in business for 40 years. And I spoke with another gentleman the other day who he started off really specific and he had three words that made up the business name. And was he was trying to like go by the acronym, but it was like something HS, and so it sounded like a high school. So he didn't even want to go by the acronym. And like literally each of the three words were a description that he wants to like no longer do anymore. Um,
Yeah.
Dang, poor. He was in business for 9 years, so I mean, 40 to 50 is a long time, but
Well, and
it
that's
doesn't take long.
you put a lot of time and effort into your business, and
Yeah.
you don't want to lose that goodwill. So
Yeah, we call it brand equity in
yeah.
the marketing world. Yeah, definitely. Well, that is such good information. I can't wait to share this. Let me see. Is there anything else? I had a little list of things that I wanted to make sure we covered. Um, what about a patent? We didn't really talk about that very much. I feel like that's more for like a recipe or a way of doing something. So that's not potentially very branding related. I think just copyright and trademark is probably the realms that we should stay within.
Yeah, it's usually copyright, trademark for branding. One thing that you can also protect that we didn't really talk about is if you've got a particular product design, um,
Oh, yeah.
that. So there's two different ways you can protect it by a design patent. But you can also protect it through trade dress, which is like basically trademark protection for an item. So the
Hmm,
iconic example is the shape of a Coke bottle. So again, it's something that you've built.
interesting.
Now, again, that has to be something that you've used for a long enough time that you've acquired rights in it. So you need to have used it so that, people know that the bottle that's this shape is Coca-Cola, that type of thing. So usually that's like a
Interesting.
5+, like a 5 to 10 year kind of thing. But if you have a product that has a really distinct design, like that might be a great thing to look at and if it's a brand new design, perhaps you're looking at a design patent. Um, and that's a part of your whole branding package. But yeah, for the most part, if you're thinking branding, you're thinking trademarks and maybe a little bit of copyright.
Yeah, that's really interesting. One of my clients has invented a heated golf glove that uses far infrared technology in it, and he definitely got that thing copy or not. He got
And
patents, and
yeah.
then also yeah, design patents and copyright for like multiple countries too. So
Yeah. Yeah. Yep. And that's the thing. You do have to protect most of the intellectual property. You have to protect country by country. So oftentimes when I'm talking to clients about foreign protection, I'm asking them, where are you manufacturing your product? And where
mhm,
are you selling it? Or if you're providing services, just which country are you providing services in? Because those are the countries you're going to want to focus on. It's not
viable to do all of them. Yeah,
feasible to protect it worldwide. So you really want to focus in because at the end of the day, so I always refer to intellectual property as sort of like a lock on your door. Like it's going to keep an honest person honest. So if you have a lock on your front
mm,
door, it's going to keep a good person out. And if someone really wants to get in, they're going to get in. And so it's kind of the same thing with intellectual property. Like
mm,
you get that protection, and most people are either going to respect it, or if you even have to file a lawsuit, you can. Um, but if someone really wants to copy what you're doing, they're going to figure out a way to do it. Um,
right.
so you
But at
have to,
least you didn't leave the door wide open.
right. So, but you do want to focus on the countries that you're doing business in, because
Yeah,
let's say someone starts using a similar name in Germany and you are only providing services in the US and Canada. Like at the end of the day, what are you losing? Because you weren't going to be providing services in Germany anyway. So
right. That makes sense. Yeah. Okay.
like it's like
Well,
caveat, like when you get really big, then yeah, you want this like
well, by then,
because you're
I mean, I want them as clients too, but most of my clients are small businesses, and that's
yeah,
kind of
same
like
here.
the very cool. So, what would the next steps be if somebody wanted to work with you to copyright or trademark something?
Yeah, so definitely reach out via email or phone. We can connect. We're located in Wisconsin, but we work with clients throughout the country. Um, and we can sort of set up a call to figure out what might be protectable and what type of protection might be appropriate, and then go from there. We work with all of our clients remotely via phone, email, and Zoom. So
That's awesome. And what's the name of your firm again?
we're Smith Keane LLP.
Awesome. And I'll make sure that there's a link to your website. Um, Thank you so much for this advice. It was such a delight to chat with you. And
Definitely.
yeah, I think this is going to be a great golden nugget to share out to the small business community. So thanks for your time.
Thank you.